Okay, from the description, you can tell where I'm at in this book, page 741. We're going to start the anti-fraud provision reading with the WARF Holdings Limited versus United International Holdings, Inc. This is a SCOTUS case from 2001. Justice Breyer delivered the opinion of the court. This securities fraud action focuses upon a company that sold an option to buy while secretly intending never to honor the option. The question before us is whether this conduct violates 10 of the Securities Exchange Act of 1934, which prohibits using any manipulative or deceptive device or contrivance in connection with purchases or sale of any security. We conclude that it does. Respondent, United International Holdings, Inc., a Colorado-based company, sued petitioner the WARF Holdings Limited, a Hong Kong firm, in Colorado's federal district court. United said that in October 1992, WARF had sold an option to buy 10% of the stock of a new Hong Kong cable system. But United alleged at the time of the sale, WARF secretly intended not to permit United to exercise the option. United claimed that WARF's conduct amounted to a fraud in connection with the sale of a security. Prohibited by Section B10 and violated numerous state laws as well. A jury found in United's favor. The Court of Appeals for the 10th Circuit upheld that verdict in 2000, and we granted cert to consider whether the dispute fell within the scope of 10B. So let's just see what the jury found in United's favor, which is probably the trial court and appeals. So for the procedural posture of this case, United received the option, and they're the wronged party here, probably bringing action. So plaintiff prevailed, and I believe that was affirmed, upheld the verdict. So important. In 1991, the Hong Kong government announced that it would accept bids for an award of an exclusive license to operate a cable television system in Hong Kong. WARF decided to prepare a bid. WARF's chairman, Peter Wu, instructed one of its managing directors, Stephen Ng, to find a business partner with cable system experience. Ng found United, and United sent several employees to Hong Kong to help prepare WARF's application, negotiate contracts, design the system, and arrange financing. United asked to be paid for its services with a right to invest in the cable system if WARF found should obtain the license. During August and September of 1992, while United's employees were working to help WARF and United negotiated about the details of that payment. WARF prepared a draft letter of intent that contemplated giving United the right to become co-investor, owning 10% of the system, but the parties did not sign the letter of intent. And in September, when WARF submitted its bid, excuse me, it told Hong Kong authorities that WARF would be the system's initial sole owner, although WARF would also consider allowing United to become an investor. In early October 1992, NG met with a United representative who told NG that United would continue to help only if WARF gave United an enforceable right to invest. NG then orally granted United an option with the following terms. United had the right to buy 10% of the future system stock. Here's the terms. And 2, the price of exercising the option would be 10% of the system's capital requirements minus the value of United's previous services, including expenses. Makes sense. United could exercise, this is third, United could exercise the option only if it showed that it could fund its 10% share of the capital requirement for at least the first 18 months. And 4, the option would expire if not exercised within 6 months of the date that WARF received the license. The parties continued to negotiate about how to write documents that would embody these terms. But they never reduced the agreement to writing. In May of 1993, Hong Kong awarded the cable franchise to WARF. United raised $66 million, designed to help finance its 10% share. In July or August of 1993, United told WARF that it was ready to exercise its option, but WARF refused to permit United to buy any of the system stock. Contemporaneous internal WARF documents suggested that WARF had never intended to carry out its promise. Various documents, along with other evidence, convinced the jury that WARF through NG had orally sold United an option to purchase a 10% interest in the future cable system while secretly intending not to permit United to exercise the option. In violation of Section 10B of the Securities Exchange Act and various state laws, the jury awarded United compensatory damages of $67 million. Part 2, Section 10B of the Securities Act makes it unlawful for any person to use or employ, in connection with the purchase or sale of any security, any manipulative or deceptive device or contrivance in contravention of such rules and regulations as the SEC may prescribe. So that's your rule in 10B. Pursuant to this provision, the SEC has promulgated Rule 10b-5. That rule forbids use in connection with the purchase or sale of any security of 1, any device, scheme, or artifice of fraud, 2, any untrue statement of a material fact, 3, the omission of a material fact necessary in order to make the statements made not misleading, 3, or 4, any other act, practice, or course of business that operates as a fraud or deceit. To succeed in Rule 10b-5 suit, a private plaintiff must show that the defendant used in connection with the purchase or sale of a security one of the 4 kinds of manipulative or deceptive devices to which the rule refers. So it's not conjunctive. Any of those 4 things can violate, and must also satisfy certain other requirements not at issue here. See 15 U.S.C. Section 78J, requiring the use of any means or instrumentality of interstate commerce or the mails or any facility of any national securities exchange. There you go. So that's always a requirement. But it seems to be from a separate rule. So, Ernst & Ernst versus Hochfelder is the source of that from 1976, requiring scienter, meaning intent to deceive, manipulate, or defraud, and from the Basic Inc. versus Levinson, which we'll read, of 1988, requiring that any misrepresentation be material, and further requiring that plaintiffs sustain damages through reliance on the misrepresentation. So this is literally all of the elements in like a 2-paragraph part of this case. In fact, it's 3 paragraphs, and I might just read it one more time without stopping. Section 10B of the Securities Exchange Act makes it unlawful for any person to use or employ, in connection with the purchase or sale of any security, any manipulative or deceptive device or contrivance in contravention of such rules and regulations as the SEC may prescribe. Pursuant to this provision, the SEC has promulgated Rule 10b-5. That rule forbids the use in connection with the purchase or sale of any security of 1. Any device, scheme, or artifice to defraud; 2. Any untrue statement of a material fact; 3. The omission of a material fact in order to make the statements made not misleading; or 4. Any other act, practice, or course of business that operates as a fraud or deceit. And this points to the Code of Federal Regulations, Section 17, Title 17, Section 240.10b-5, 2000, from 2000. To succeed in a Rule 10b-5 suit, a private plaintiff must show that the defendant used, in connection with the purchase or sale of a security, one of the 4 kinds of manipulative or deceptive devices to which the rule refers, and must also satisfy certain other requirements not at issue here. See Title 15 of the United States Code, Section 78J, requiring the use of any means or instrumentality of interstate commerce, or of the mails, or of any facility of any national security exchange. Ernst & Ernst versus Hatchfeller and of 1976, requiring signature, meaning intent to deceive, manipulate, or defraud, and Basic Inc. versus Levinson, 1988, requiring that any misrepresentation be material. Further, requiring that the plaintiff sustain damages through reliance on that misrepresentation. In deciding whether the rule covers the circumstances present here, we must assume that the security at issue is not the cable system stock, but the option to purchase that stock. That is because the Court of Appeals found that WARF conceded this point. WARF does not contest on appeal the classification of the option as a security. That concession is consistent with the language of the Securities Exchange Act, which defines security to include both any option on any security and any right to purchase stock. Oddly, that's from 15 U.S.C. 78C A10. So the definition of security now is important too. Consequently, we must decide whether WARF's secret intent not to honor the option it sold to United amount to a misrepresentation or other conduct forbidden by the rule in connection with the sale of the option. WARF argues that its conduct falls outside the rule's scope for 2 basic reasons. First, WARF points out that its agreement to grant United an option to purchase shares in the cable system was an oral agreement, and it says that 10b does not cover oral contracts of sale. There is no convincing reason to interpret the Act to exclude oral contracts as a class. The Act itself says it applies to any contract for the purchase or sale of a security. Oral contracts for the sale of securities are sufficiently common that uniform commercial code and statutes of frauds in every state now consider them enforceable. So oral contract for securities is enforceable. A contract for the sale or purchase of a security is enforceable whether or not there is a writing signed or record authenticating authenticated by the party against whom the enforcement is sought. Any exception for oral sales of securities would significantly limit the Act's coverage, thereby undermining basic purposes. Second, WARF argues that a secret reservation not to permit the exercise of an option falls outside Section 10b because it does not relate to the value of a security purchase or the consideration paid. Hence, it does not implicate Section 10b's policy of full disclosure. Brief for petitioners 25, 26, emphasis deleted. But where it is the case that the Act covers only misrepresentations likely to affect the value of securities Wharf's secret reservation was such a misrepresentation to sell an option while secretly intending not to permit the option's exercise is misleading because a buyer normally presumes good faith. Restatement second of torts, section 530, comment C, since a promise necessarily carries with it the implied assertion of an intention to perform, it follows that a promise made without such an intention is fraudulent. For similar reasons, the secret reservation without such intention is fraudulent. For similar reasons, the secret reservation misled United about the option's value. Since Wharf did not intend to honor the option value, the option was unbeknownst to United valueless. For these reasons, the judgment of the Court of Appeals is affirmed. And let's just bleed into the next section and maybe take a break to take notes. What will result in Wharf Holdings Limited if the facts establish that only after entering the agreement with United did the defendant decide not to honor its contractual obligation to United? This question invites the application of the in connection with element of the anti-fraud provision, section 10b, and Rule 10b-5 prescribe manipulative and deceptive acts that are in connection with the purchase or sale of any security. Although this language calls for there to be some nexus between a violation of Rule 10b-5 and a purchase or sale, the courts have interpreted the term in connection with broadly any statement that is reasonably calculated to affect the investment decision of a reasonable investor will satisfy the in connection with requirement from Hazen Securities Regulation 540 to 541, 6th edition, 2009. If Wharf decided not to honor its contractual obligations to United after United decided to fulfill its part of the bargain, would Wharf's breach have impacted United's investment decision? Interesting question surrounding the meaning of an in connection with requirement. Fraudulent misrepresentations to a bank to obtain a loan for which securities are to serve as collateral were not deemed to be in connection with the purchase or sale of securities, even though a pledge of securities is a sale. See Chemical Bank versus Arthur Anderson. Cool. Cert denied in the Second Circuit, 1984. And in Gavin versus AT&T, 7th Circuit, 2006, the court held the broker had not committed fraud in connection with the sale of securities. In Gavin, a plan of merger approved by the stockholders of each company provided stockholders of the disappearing firm with a variety of options by which they could be compensated for their shares. The defendant broker was retained to administer the plan and sent a notice after the merger's consummation detailing most of the plan stated that for a $7 fee, but without disclosing that one of the options available to the shareholders did not involve any fee to the broker. The court held this omission, although material, was not in connection with the sale of a security which under standard corporate law had occurred earlier following the stockholders' approval and filing of the necessary documents with the Secretary of State. On the other hand, in SEC v. Zanford of 2002, a unanimous Supreme Court held that requisite nexus existed where the broker systematically misappropriated proceeds of the sales of his client's securities. The client, who was quite elderly and in poor health, granted the broker full discretion to engage in securities transactions without the client's prior approval. Over a 2-year period, the broker repeatedly sold securities from the account and misappropriated the sales proceeds, which approximated $343,000. The court found the requisite linkage by reasoning that each sale was made in furtherance of the fraudulent scheme to misappropriate the funds, reasoning rather broadly that the client was duped into believing the broker would conservatively invest their assets in the stock market and that any transaction made on their behalf would be for their benefit. What would have been the result had the broker had received funds from the client on the pretense they would be invested in securities, but instead the broker embezzled the funds? And to answer that, look at a 2008 case, VR Global Partners LP versus Bennett, from the Federal Supplement. So, we didn't get incredibly far, but let's just get to the end of Section 1. The Section 1 is the introduction before we go into the next part. What is a misrepresentation? So for a note on private actions under Rule 10b-5, the Wharf Holdings Limited versus United International Holdings, Inc. was a private action. That is, it was an action brought by a private party for private relief damages rather than an enforcement action brought by the government. Neither Section 10b of the Securities Exchange Act nor Rule 10b-5 explicitly provides for private actions. However, there is a long so there isn't explicitly a provision for private actions. However, there is a long tradition in American law allowing private parties to bring actions based on violations of statutes or administrative rules in appropriate cases. What kinds of cases are appropriate for this purpose is the subject to principles whose content has changed somewhat over time. The most salient principles for present purposes are summarized in the descriptions of J.I. Case Co. versus Borak Windot versus United States. And Court versus Ash set out at the beginning of Chapter 5. Under these principles, the courts have held that some provisions that the Securities Act and other rules thereunder give rise to private actions and others do not. The Supreme Court formally upheld the implied provision right of action under Section 10b and 10b-5 in Herman and McLean versus Huddleston of 1983. So what does that say? The Supreme Court finally upheld the implied. Okay, so it's implied right of action. Private right of action. And with that, I'm going to stop the recording because we're going to go into a new section. What is the misrepresentation after this?